Now I will discuss Article 22, Article 23 and 24 of the Constitution. Article 19 to Article 22 of the Constitution deals with right to freedom. So Article 22, if you read the Article 22, you will find safeguard against arbitrary arrest and detention. If you read the Article 22, you will find 7 clauses. So we'll discuss all these clauses. What are the provisions? What are the safeguards which provide us against arbitrary arrest? Article 22, Clause 1 and 2 deals with the 4 important rights of the arrested person. So, the, there is a well settled principle that accused person should be innocent. Accused, it is a well settled principle. Well, accused will be presumed to be innocent till it is proved beyond a reasonable doubt. So it is a duty of the prosecution to prove that accused has committed the crime. So he should be treated with human dignity till it is proved that he has committed an offense. He has committed crime. So you will find the various protection are given to the accused person, that is accused person under the Constitution. Article 20 we have discussed. Under Article 20 you will find the various kind of protection, and under Article 19 you will find the protection. Under Article 21 you will find the protection to the accused person. Right to not speak, right to silence, right against double jeopardy rights is there. So various rights are given to the accused persons. Article 22 deals with right arbitrary arrest. So first, the Article 22 is not a complete code. What do you mean by it is not a complete code? Article 22 is not a sole article to protect arbitrary arrest. Article 21 is there. Article 19 is there. So what is Article 9, 2020 deals with the law must be reasonable, fair and just. If there is a Article 20 is not a sole article to protect arbitrary arrest. So certain law must fulfill the conditions of the Article 20, Article 19 of the Constitution. If there is a it is not, so it is not a sole article. So we'll discuss. If you read the Article 20, Clause 1 and Clause 2, you'll find a four rights. Sorry, four rights. First right is accused to be produced before the magistrate. To be produced before the magistrate, the ground of arrest should be given to the accused. The person authority, the authority which is arresting the person should communicate the ground of arrest to the accused person. This is the rights. Again, second right is that the arrested person has right to employ lawyer of his choice or to consult with his lawyer regarding the arrest arrest. So these are rights. These two rights are guaranteed under Article 20 Clause 2. Article 20 Clause 2, you will find the two rights. Accused person should be produced within 24 hours before the magistrate. First right, and second right, accused person should not be detained more than 24 hours without order of the magistrate. These are the without the magistrate. These are the four rights are guaranteed to the accused person. So what is the clause 3 of the Constitution? Clause 3 of the Article 20. Clause 3 of the deals with exception. Article 20 is available to citizen as well as non-citizen, but Article 20 Clause 3 deals with exception. What is the exception? Enemy aliens and detained person as per the detention law will not get these rights. Alien enemies and detained person will not get these rights. the rights guaranteed under clause 1 and clause 2 of article 22. So what is the clause? These are the three clauses dealing with the person is arrested as per the ordinary law. Now we'll discuss the clause 4 to clause 7. Clause 4 to clause 7 deals with the person is arrested as per the preventive detention law. So there is a difference between the person is arrested as per the ordinary laws and person arrested as per the detention laws, preventive detention law. In case of preventive detention, in case of arrest as per the preventive detention law, the, the person has not committed any crime. Only preventive action is taken by the authorities. There is chances on the certain grounds. There is chances public orders, security of the state. So peace may be disturbed, breach of peace of public chances only on that. So preventive action is taken by the authorities. So preventive, it is not a penal actions against the person. So hence the detained person should get more rights. The detained person against will not find this kind of provision in other constitution. This is constitutional protection is given. Constitutional protection is given to the detained person. This provision in most of the country you will not find a preventive detention laws. In India, you find the preventive detention law as well as constitutional protection is there. So clause 4 deals with the preventive detention law. There should be a maximum detention 3 months is there. 3 month period is there, but by 44 constitution amendment you will find the amendment is there, and the 3 detention should not be more than 2 months, should not be no except except if the detention is more than 2 months, then it must be referred to the advisory boards, and it must be recommended by advisory it must be reviewed. The detention order must be reviewed by the advisory boards. If it is not reviewed by the advisory boards and it is not recommended by the advisory boards, then detention will be ceased once the expiry of the 2 months is over. Is over. So these are the provisions under clause 4. What is the clause 5? Clause 5 deals with the two rights of the detained person. The detained person, as per the preventive detention law, the person who is detained, that is communication of the grounds of detention. So detaining authority should communicate the ground of detention to the detained persons. And second right is he should be given opportunity to represent. The detained person should given opportunity to represent. So these are the two rights are guaranteed under clause 5 to the detained person as per preventive detention if the person is arrested as per the preventive detention law. Next clause, that is clause 6. Clause 6 is the exception to clause 5. What is clause 5? Clause 5, ground of detention must be communicated to the detained person. But clause 6 is saying that uh, in, on public interest, it is not detaining authority is not bound to communicate the ground of detention. So it is against vague concept. Clause 5 is uh, saying that ground of arrest detention should be communicated, and clause 6 is saying that not bound in every case on public grounds detaining authority is not bound to disclose the ground of detention, is not bound to disclose the ground of detention. This against vague uncertain provisions and uncertain in clause 6. Clause 7 enable the parliament to make law, and by that law detention may be more than 2 months. But there is an amendment now, detention cannot be more than 2 months without recommendation or without recommendation of advisory board, which so there must be advisory boards and it must be recommended by the advisory boards. These are the provision of the article 2022. Now we'll discuss the cases. The Maneka Gandhi versus of India. The concept, the scope is header of article 20, and as per the Maneka Gandhi's case, every arrest, every law must be just fair. Even the preventive law or any other law must be fair, just fair. If law is just fair and reasonable, only person can be arrested as per that ordinary law. Against Joginder Kumar versus State of PP is a second landmark case decided in 1994. In this case, if the person is arrested and the arrested person requests that he want to inform to the relative or friend, then the arresting authority must take the notes of it and inform to the concerned friend or relative of the accused regarding the accused person is arrested. Regarding the accused person is arrested. Next, police officer shall inform the arrested person when he is brought to the police station. An entry shall be made in the police diary as to who was informed of the arrest. If the arrest, these are the guidelines laid down by the Supreme Court in Joginder Kumar versus State of UP in 1994. Two important guidelines had been laid down. If the accused person or if the arrested person want to inform to the relative or friends, then police officer should make the should inform such a should comply with these provisions. Should against and it should be noted down in the police diary. Then next landmark case law, Hussein Ara Khatun versus Home Secretary Bihar. In this case, Supreme Court held that it is the constitutional right of the every accused person who is unable to engage lawyer and secure legal service on account of poverty, indigence. Then in that case, to have legal to free legal service provided to him by the state, and the state is under constitutional duty to provide a lawyer. This is the Hussein Ara Khatun versus State of versus Home Secretary Bihar. Next important case law on Article 22, CBI versus Anup Kulkarni. This is one of the important case law dealing with the guidelines. If arrest investigation, this is the case law regarding if the investigation is not completed within 24 hours, then in that case the guideline is laid down by the Supreme Court in CBI versus Anup Kulkarni. As per section 57 CRPC, accused should be produced within 24 hours. Accused should be produced, arrested person should be produced before the court within 24 hours. That is, there is a provision in CRPC as per section 57 as per against under Article 22 of the Constitution. Next, judicial magistrates can authorize the detention of the accused in custody. Only judicial magistrate can authorize detention of the accused in custody after 24 hours. If after 20, without order of the magistrate, if there is a detention, then such a detention will be considered as an illegal detention. After the next guidelines, after the expiry of the first period of 15 days, the further remand can only be in judicial custody. If the accused person is is kept in police custody for 15 days, next if there is a need of the judicial custody, then after 15 days there must be a judicial custody, not a police custody. If the investigation is not completed within 19 days, then accused should get the benefit of the bail. So accused should be released on the bails. This is the guideline laid down in CBI versus Anup versus Kulkarni. So accused should next landmark case law regarding on the Article 22. Lallubhai Jogibhai Patel versus Union of India. This is the case. In this case, detainee did not know English language. The ground of detention were drawn in English. The detaining order stated that the police inspector, while serving the ground of the detained, fully explained the ground in Gujarati to the detainee. So we have discussed that clause 5 of Article 22 deals with there is a ground of detention must be communicated to accused person. Ground of detention must be communicated to the arrested person. If the ground of arrest is not, suppose the ground of arrest is communicated to the detainee in language which is not understood by the detainee persons. Is it validly complied by the detainee authority? No. The ground of the detention should be written in the language which the arrested person can understand. So the in Lallu Bhai Jogi Bhai Patel version of India, in this case the ground was not explained, was not in language of the in the language which the arrest person can understand. Hence the detention order was held invalid, illegal, invalid. And it was held that there was no sufficient compliance of Article 20 Clause 5. Next important case we'll discuss, that is Kubik Darus versus of India. In this case, the ground of the detention was served to the detainee in English. The detainee acknowledged the receipt thereof, putting his signature in English. Then, after the 1 month, detainee made a representation that he knew only Polish language, not English language. So, in this case, Supreme Court held that accused has a knowledge of English language and he is showing ignorance. So, in this case, the benefit of did not get to the accused person, and hence next important case law, that is State of Bombay versus Atmara. The ground of detention must be in existence at the time of making the orders. This is the case. In this case, Supreme Court has held that the ground of detention must be existent at the time of making the order. No part of such a ground can be held back, or nor can be new ground added to the there. This is the principle laid down in State of Bombay versus Atmara. Again, the next important case law, Ram, Ram Bahadur versus State of Bihar. It was held that where the orders of detention was based on the distinct and separate ground, and if any of the ground was vague or irrelevant, the entire order will fail. Next important case law on the Fogla and S.K. Jalil versus State of West Bengal. In this case, court held that where one of the reason for detention was not communicated to the detainee, it was held the detainee had no opportunity to make an effective representation to the government, and hence the detention was violative of Article 22 Clause 5 and must be set aside. So Article 22 deals with the right to represent and right to know the ground of detention. Clause 6 deals with deals with the exception, and clause 7 empower the parliament to make law regarding the extension of the period beyond 2 years. So these are the provisions of Article 22 of the Constitution. Thank you.